literacy and intellectual property rights and cyber law, cyber legal regimes in India by being a visiting faculty in Nalsa Pro patents, cyber and media law courses. Okay, so other than helping us out with patent law course, sir also is part of our cyber law, media law courses. Okay. Muralidharan sir is also a life member of Indian Society of International Law, New Delhi. He's a mediator at Bangalore Mediation Center, and he regularly attends and acts as resource person in professional improvement programs in IP law, environmental law, international law in India and abroad. And as I said, for me, he is also like my teacher, because when I was a student in Nalsar, sir was here as a resource person for the same course, and I have attended his lectures as a student too. So sir, welcome. I welcome you to this contact classes, and next two sessions are for you. So the floor is yours.
Thank you very much, Professor Bharti. Very nice. Ladies and gentlemen, good to see you all here. I don't know how many of them...
One thing, at the back end, we have Mr. Ravi, and we have back end people available. Mr. Ravi is there, so if there's any issue, you can talk to them and they'll respond to you.
Okay, right. Okay, nice. Okay, good to see you all. How many people are attending today?
So right now I can see 32.
32.
I think some people will join.
Yes.
For my first lecture, there was close to 60 people.
Right. I'm just trying to understand it. Thank you very much, Professor Bharti. Now, let's begin with the course without any further intros. I have put on the slides 3 wisecracks. The first is by Rabindranath Tagore. Where the knowledge is free, into the heaven of freedom, my father, let my country awake. Now the question is, Tagore is a romantic idealist. He's one of the best, obviously. That's not for nothing. He was given a Nobel Prize. He was thinking of an ideal situation where the knowledge is free. Now the question is, whether the knowledge is really free in the world. We have become an information technology driven society. Now, the knowledge is not always free. Okay? If it is free, well, there is no meaning for IPR. IPR is monopoly over knowledge. Now, the basic question that every scholar asks in economics is whether the monopoly is good or bad. The answer will depend on who is going to have the monopoly. If I am going to have the monopoly, monopoly is wonderful. If you are going to have monopoly, monopoly is terrible. So, an IPR lawyer strives a lot to secure more and more enforceable monopolies for his client and further ensure that his competitors do not get such monopolies so easily. Okay, so please remember, monopoly becomes good or bad depending on who is going to have it. This is the first wisecrack. And this makes Mr. Rabindranath Tagore not all that very correct, right? If you are really talking about a situation where the knowledge is free, into the heaven of freedom, my father, let my country awake, I think IPR laws are achieving exactly the contrary. All right, I am not getting into philosophical discussions. We have an Indian Patent Act, and we have that law. And many of you, I am sure, will be appearing for the patent agent qualifying examination this year. So let's get on to our patent business. What is this patent business? Patent, according to Thomas Alva Edison, is a license to a lawsuit. I want you to appreciate that patent held a record for maximum number of patents for an individual. Now that record has been recently surpassed after about 100 years actually. That too by an Indian. That's the same story. Patent is a license to a lawsuit. What can you do if you have a patent? If somebody infringes your patent, you can sue them. So it becomes really a license to a lawsuit. Now, in my language, Tamil, there is a proverb that says, don't go behind a donkey or in front of the court. In Kannada language, where I have settled down now in Karnataka, there is a proverb that says, the guy who goes to court and wins actually loses, and the guy who goes to court and loses is as bad as dead. So, going to court is not a very nice proposition for most in India. With this attitude, we cannot take advantage of the patent system. 3. Owning a patent is like owning an elephant. Guess who? It is me. I say this actually because owning a patent is a very expensive business. Okay. Now, the point I'm trying to tell you here is an Indian patent may cost you something like 3 lakhs, okay, from filing to the disposal. Maybe if you are having more number of filing, you will have different rates. But as a rule, if you look at it, owning a patent is like owning an elephant. Meaning, if you have to own an elephant, you have to give it 10 kilos of germinated legume, 3-4 kilos of jaggery, 250 kilos of vegetation. And you should have something like 4,000 feet committed area for the elephant and 2 assistants to manage them. That is what owning a patent will entail actually. Okay. Now that is necessarily a very, very expensive proposition. Right, I skipped the cartoons. Have a look at it, read this PPT at your leisure, reflect on the wisecracks which are there actually. Now this is your first lecture. As a teacher, I believe that there are 2 things in learning. One is giving essential up-to-date information on the topic. The other is providing accompanying skills. What you do with the knowledge. This is very, very important actually. Acquiring knowledge is one thing, application of knowledge is another. A good professional has to have not only up-to-date knowledge but also accompanying skills. We are talking about skill development programs. And when you understand patent law, that too from a professional like me, I would like you to focus more on the skill acquisition rather than provision of information. You have this patent act, right? It is in English. You all can read it. And please do read it. It is very, very important actually because I'm going to probably have with you 150 minutes. And in this 150 minutes, I am not too sure how much of information I'll be able to provide to you. Now, let us begin with the criteria for patentability. The criteria for patentability is, okay, I have that as the Nun's test. Nun's test means, as you see it on the screen, novelty, utility, non-obviousness, statutory subject matter. For you to qualify for a patent, you must meticulously comply with each of the 4 requirements. If one of the 4 requirements is missing, you will not get a patent. So, before we decide to apply for a patent, we have to make sure for yourself that we have this novelty, we have this utility, you have this non-obviousness, and it is also known by the name inventive step. And also something very peculiar to the Indian patent law, namely section 3 of the Act, statutory subject matter, nuns. I told you that today we have what is known as a Modern Competition Act in India. If you look at the scheme of the legislation, even under the Indian directive principles of the state policy enshrined in the Constitution, the state shall ensure that means of productions are not monopolized in a few hands. Technology is undoubtedly one of the important means of production. Okay? And patents give monopoly over technology. Please remember that Indian law does not encourage monopolies. It only tolerates it. Patent law is an exception to the general rule against monopoly. Now I told you that patent is granted based on 4 essential requirements being present in your invention. The first thing is novelty. I also want you to appreciate that in this nuns, novelty, utility, non-obviousness, the criteria is global. Meaning, the requirements of novelty is the same, whether it is United States or India, whether it is Australia or China, because this is a concept which is more or less the same around the world. Utility, capable of being industrially applied. This is also global. Non-obviousness, something which is not obvious to a person skilled in the art. This is also global. But only that section 3, patentable subject matter, non-patentable invention, that is the only thing which is peculiar to India. Every other criteria is just the same actually. Now, novelty can be ascertained by a prior art search. Now, doing a prior art search is very, very easy, ladies and gentlemen. You just have to Google it actually, okay? Google has got a wonderful database. When I got into the profession, there wasn't any Google. So novelty search is a big job. You know, it may take about 3 or 4 days or probably even a week to complete it now. You got to go to the patent office, check for the documents, whether any patents have been filed in India in respect of it. All this is gone now. Now what you need to do it? Simply Google it actually, okay? Now, a novelty is lost in 3 situations. What is novelty? We will understand that. To begin with, I want you to appreciate that novelty is lost in 3 situations. First one is prior claiming. What do you think as your novel invention today has already been claimed by somebody as part of their patent monopoly? You go to the WIPO database, you will get whether anyone had already claimed what you think you are claiming. 2. Prior publication. Many research institutes have a policy not to patent. Some of them may not have a budget for patenting. So what they will do? They will do what is known as protective publication. They publish the results not so much for them to take a patent for themselves, but to ensure that nobody else in future claims this technology as their own proprietary technology. So, prior publication also defeats novelty. The third thing that defeats novelty is prior public use. This is mean that the product which employs the technology is already available for sale in the market. So, prior claiming defeats novelty, prior publication defeats novelty, prior public use defeats novelty. Okay. So this is something that you can do thereafter. The next concept is utility. Utility means it is capable of industrial application. What do you mean by capable of industrial application? Refers to the invention which is being made or used in an industry. This is very important actually. Now, industrial applicability means it should produce the same result every time. Subject to NTP. NTP is normal temperature and pressure. That's what the scientists use. STP is standard temperature and pressure. For example, you must have watched the recently concluded cricket match. Different types of balls are bowled by the bowler. Good length ball, short of length ball, outside the off stick ball, outside the leg stick ball. But each time the player is going to play, he may not necessarily play the same way. Okay? So it is not something, that is why method of playing a game is not considered as something which is industrial application, meaning it should produce the same result each time subject to the normal temperature and pressure. Now, this is something which is very, very important actually. Inventive step or non-obviousness. This is the third important criteria. I told you earlier, novelty, utility and inventive step more or less is the same all over the world. Only the fourth part, namely statutory subject matter, differs from country to country. Non-obviousness means, this is an expression which is defined under the Indian Patent Act, Section 2JA. Now, non-obvious means it must involve a technical advance, economic significance, or both. I can give you some illustrations actually. When your ancestor traveled in the 19th century, he used bullock carts or horse carts. Okay. When your grandfather used the first of the buses that the Indian roads saw, the first of the buses used coal as a fuel. Okay. Subsequently, the buses started using petrol. And thereafter, the buses started using diesel. Now, the buses in Delhi use LPG. And now, the buses around the world use electricity or green hydrogen, the fuel for the bus. Each one involves a technical advance. And what is this economic significance? A lot of things have changed. Today, when I go to a class, I don't find an ink pen, right? You find either a ball pen. The ball pen had metamorphosed into a micro tip pen, jumping ball pen, roller ball pen. You understand? In pen, you have different improvements. And the sum of it, pen today, earlier we have this proverb when we were in school. Pustakam vanita vittam parahastam gato gatam. Meaning, we'll never give your pen to anybody else when I was a student. Nowadays, when you attend seminars and all that, they give you a pen which is less than 2 rupees old. So if somebody asks you for a pen, you give the pen free to that person and go. Because the economic cost of the pen has come so much. So what I am talking about is two concepts here. Inventive step must necessarily involve a technical advance. For example, image viewing technology, television, When I was a postgraduate student, the most priced product in a middle class house is video cassette recorder and player. I don't know how many of you have used it or seen it actually. Video cassette recorder or player. Now if you want to give somebody a video cassette recorder or player, they will look at you with contempt and say, hey, what the hell here? I'm getting the best pictures possible in my Android mobile phone. So if you have junk, put it in the electronic waste bin, don't give it to me. So this has made a very big change. Nobody today wants a video cassette recorder or a player because they have lost their economic significance. It used to cost about 10,000, 12,000 a day when professors were drawing salary of about 10,000 rupees a month. You understand? Now that is something, economic significance. For example, I waited for about 5 years for me to get my first landline phone. But today, if you want a phone, if you have your Aadhaar card, right, and a PAN card, you will get it in 15 minutes actually, right? So that means a very big technical advance. We are a country of about 1.4 billion people, and somebody like 800 million people have a mobile phone, and more than 500 million people regularly access to internet. Okay? And please remember, the word expression inventive step also involves a feature which is not obvious to a person skilled in the art. Now, who is a person skilled in the art? A person skilled in the art is a relative expression. In law of tort, we have an expression called reasonable man. Who is a reasonable man? That's a very difficult question. A reasonable person is one who will depend upon the circumstances actually. Like that, the expression person skilled in the art is a person with an university degree in the relevant discipline and with about 3 years of industrial experience. Okay. Now, university degree alone does not give you problem solving skills. And you go to an industry and work, you will find a lot of problem. Most of the problem, people naturally do a bit of trial and error actually, right? With each trial, with each error, you will become wiser. So you will develop a lot of problem solving capability. And person skilled in the art, if he is able to find the solution like the inventor by a reasonable trial and error, you can say that there is no inventive step. By the way, ladies and gentlemen, if you have any comments or questions, you can draw my attention or type it out, okay? At the end of the session, I will read out all your questions and try to consolidate it and answer it actually. I want my classes to be a dialogue mode, but I know that I am doing it online and I may not be able to individually attract the attention of each one of you. And if you have any comments or questions, do ask, do type it out, and or click your video screen and ask me. I have no issues actually. Whichever way that suits you most, you can do that actually. All right. Now, I always want to tell you something. You know what you see on the picture at the bottom? This is the Starbucks coffee. Okay. Now, this is a very interesting invention. Because in olden days, you go for a coffee in a restaurant, they either serve you in glasses or in stainless steel container. After each use, they will have to be meticulously cleaned. And not only you should clean, but also you should drain each glass carefully. My biggest worry whenever I had gone for restaurants and drink coffee is that, number one, do they wash the cups properly? You know, we all have tricks like we use the left hand for the purpose of sipping the coffee, not the right hand. Because everybody, most of them are right-handers. And when they take the coffee, the right side always comes in contact with the lip actually. And we are not sure if they are changing the wash water, and we are not further sure if the water has been properly drained after washing, and even about 2 or 3 drops present there, okay, can give you the infection and give you a very bad tummy the next day. Now, how did the Starbucks solve the problem? This is actually a patented invention, mind you. Okay, I'm taking very simple illustrations for you to appreciate what is this inventive step concept. See, the white part of the cup that you see there at the bottom is made of biodegradable plastic. And the coffee is served to you at about 60 to 70 degrees Celsius. Now, that is why when you touch a stainless steel container, if it is not a ceramic mug, you will find it very difficult to hold the cup actually, because it is too hot. The same with this plastic. This is made of biodegradable plastic, which means after each use, the person simply crushes the plastic and it becomes nitrogen, carbon dioxide in due course. But if we have to use it alone, number one, it is very flimsy. It has to degrade, right? So it can be very easily crushed. And if you crush that, the coffee will spill. So the company comes up with what is known as the bottom collar. The brown color cardboard thing that you see below. This coffee collar, which is going to fit at the bottom of the bottom of the cup. This, after each use, the restaurant guy will remove the bottom collar, take the cup, put it in the dustbin, and it will go. So what I am trying to tell you here is, simplicity of the invention is no bar to patentability. It is a very simple thing here, okay? Having conductor cup and a non-conductor collar, okay? So that makes the invention very simple. These things are known, but it has had a very big advantage. Now let me look at that. I am showing you 3 key parts actually. Now, first is identifying an invention. What is an invention? Okay, you know that every time an industrial problem is solved, some technology is generated here. You have to recognize that. Now, what is that some technology? Whether that technology is a patentable technology, all these are questions. Now you see the 3 parts, and what you see in the 3 parts, what I can see as invention is, number 1, there is a handle, right? Handle makes it easier for you to carry the vessel. Number 2, lid. It further makes sure that the contents do not spill out. Number 3, there is a spout through which you pour the coffee. So there are 3 of these concepts are present there. Now if you ask me whether providing a handle to the vessel, providing a lid to the vessel, providing a spout to the vessel, will it qualify for a patent? This is the basic inquiry. Now, it will not normally, because if you tell a vessel designer, a person skilled in the art, describing the problem, easy to carry, provide a handle. This is something a person skilled in the art will automatically come up. I want to ensure spillage of the content as and when I carry the vessel. Put a lid. I want to ensure that when I pour the contents, it should not spill. Provide a spout. So, if you tell this problem to a person skilled in the art, he will come up with that solution. Now, you look at this actually. Here, you have, instead of one spout, you have two spouts. Spout is known, right? The purpose is to pour through it. But here what you see is, instead of one, you see two. It's already there. You are only duplicating it, increasing the number. This doesn't have novelty. But let me give one step ahead. Now, if this cup inside provide a partition, okay, and make it that each of the chambers within the pot do not mix. So this pot can be used for serving coffee as well as serving the tea. So if you are a person serving coffee in public places, someone wants tea, someone wants coffee, okay. Maybe the ratio is 50-50% actually. So from coffee you can pour from this spout, and tea you pour from the other spout. So here, that's what I am trying to tell you, that the simplicity of the invention is no bar to its patentability. Here, you look at it, two issues. Number one, what you have is a small cup which people use for the purpose of drinking coffee. Now, a cup of this size does not necessarily need a handle, right? It's a ceramic, it is a non-conductor. So if you are going to touch the external surface of the cup, it's not going to be hot. So why do you have handles here? Should the handles be very big like this? Normally we don't need. But just imagine, this is meant for children with neuromotor disabilities. People, they cannot really hold things actually. Their bodies shake, their hands shake, even when they take the coffee cup to their mouth, it will shake, they will end up spilling on them. So for them, so beauty is in the eye of the beholder. That's what I want you to appreciate. Okay, so sometimes you can say, oh, this cup, it's a terrible design. A small cup like this doesn't need two handles. But if you see that the target audience of the cup are children with neuromotor disabilities who have a tendency to spill things, right? For them, this cup is a wonderful thing. Right. Now, I told you that now we are getting into what is known as the most unique thing of the Indian patent system. I told you novelty, utility, non-obviousness, all these things are common to the world. Now this statutory subject matter differs from country to country. Now what I am going to do in the next few hours will be, now what are the special difficulties faced by the Indian innovator and how the Indian innovator can overcome the problem posed by Section 3. Section 3 is very unique to India actually. Please remember that most of the Western countries are quite unhappy with the Section 3 of the Indian Patent Act, because you have something like 12 or 13 different types of invention which have been declared to be non-patentable by the section itself actually. This makes the Indian patent system one of the most restrictive patent systems in the world. I want you to appreciate that India is perceived to be the most patently unfriendly country in the world. I want you to appreciate that actually, because please remember Indian Constitution, which is the basic law which gives authority to the legislature to pass this Patent Act. In fact, if some part of the patent law contradicts with the Indian Constitution, patent law will go. Nothing can go against the Constitution. So, Indian Constitution, in its preamble, declare ourselves to be a socialist country, when the rest of the world believe that they are capitalist actually. Okay? There is no socialist country in the world today. Only North Korea and Cuba. Nobody wants to go there actually. You understand what I am saying? Now, first is we declared ourselves to be a socialist country in the world. Second is, in India, right to property is not a fundamental right. It was. Okay? By the 42nd Constitutional Amendment, the right to property has been declared to be merely a statutory right. Okay, this is something very peculiar. And we are a country of about 1.4 billion people here, right? So we don't like monopoly over knowledge. We have a patent system because, we want to align our economy with the rest of the world. And the rest of the world believe in a patent system. You understand? But India, right from the very beginning, has been very skeptical about the patent system. Now, I want you to appreciate, globally, there are three main schools in patenting. The first is the American, Japanese, and the Israeli school. In these countries, anything under sun capable of improvement by human effort is valid patentable subject matter. Look at it, Diamond versus Chakrabarti. Okay, you know that Chakrabarti is an Indian origin American. He invented a bacteria that will break up the oil which gets spilled in the sea and make the oil relatively less harmful substance and become part of the planktonic food chain. So it's a very good invention. In Diamond versus Chakrabarti, the United States Supreme Court permitted the patentability of even microorganisms, which is a man-made species actually, a new species made by the man, human. Okay, I will use the expression human so that I use a non-sexist language, gender-neutral language, which is very important for all of us to pick up today. Right? So in the American, Israeli and the Japanese school, anything under sun capable of improvement by human effort is valid patentable subject matter. The second school is European school. In Europe, it's a very interesting society. They have declared that they will have a very liberal regime for patenting. Anything useful, anything novel, anything that reduces human drudgery in the world will qualify for patent protection. So on the ground they say, look here, see, this is again a very important question, but at the same time, the European Patent Office says that if an invention is against the ordinary public morality, then they will not grant a patent. What is this ordinary public or morality? And the word morality, we will find it also, it differs from person to person. If you are a woman activist, there can be two role models. One is Mother Teresa, okay? She impressed rest of the world by her selfless service. The other is Pulan Devi, right? Pulan Devi suffered a lot of injustice when she was growing up and she became a dacoit and she came back into the national mainstream. She became a member of parliament. So, I may not probably like to date Pulan Devi, but nevertheless, if you are looking at it as an icon of woman empowerment, right? Okay. I mean, she, murderer, all that is different here. I'm not getting into that. You know, that's why Mr. Mulayam Singh Yadav made her a member of the parliament, because you have the ability to fight against the system. And the fact that you have been subjected to a lot of dehumanizing, demeaning act did not prevent her from achieving what she wanted to be. She was a leader which she achieved leadership. Mother Teresa is also a leader in her way. So the morality of the Pulan Devi differs from the morality of Mother Teresa. So in Europe this problem came. That is, when the date drugs were introduced, okay, that is making people to feel sexually inclined when they were otherwise not. They thought that these drugs will promote debauchery. But then the court, we will be talking about it actually, court came to a conclusion that good lot of people have some difficulty in sex, and for them the date drugs can be a useful thing actually. So even for a date drug, the European Patent Office granted a patent. Now, we will get into section 3. Now, whenever I do this lecture, in my regular classes, I give a 30 seconds break. The 30-second break is for you to read what is in the screen and try to apply your mind with reference to the illustration I am going to give you. So please remember, only when you continuously test your knowledge and your problem solving ability, you will pick up skills. Knowledge you will acquire by reading the statute. Now, an invention which is frivolous, which claims anything contrary to well-established natural laws. Read it again. An invention which is frivolous. In English language, there is a proverb. Beauty is in the eye of the beholder. What is frivolous to you may be wonderful to me. What is wonderful to me may be frivolous to some other person. Okay? So, it differs from person to person. If you want to claim anything obviously contrary to well-established natural laws, this is actually a problem. I want you to read it from reverse. Last word is laws. The word preceding it is natural. The word that precedes natural is established. The word that precedes established is well. So look at it, well-established natural law. This is a highly loaded expression. You understand what I am saying? I can understand laws. I can understand natural laws. I can also try to understand what is an established natural law and what is a well-established natural law. For example, sun rises in the east. Okay, this is an well-established natural law. Ever since we have the earth, the sun has been rising in the east and setting in the west. Suppose you change the position of sun in relation to the sun, it is theoretically possible for you to shift the earth to a place where the sun rises in the west and sets in the east, right? Theoretically possible, okay? Now, such kind of patents are not allowed. Now, let us understand one more illustration and I will skip this slide. Please, don't get disheartened. I'm just trying to understand. These are the difficulties in understanding section 3. Now, we are all, I'm a homo sapien, right? Human being. I belong to the phylum Vertebrata. Now I have a back pain. So I know that I have a vertebral column, right? A backbone, right? The expression backbone could mean different things to different people. If somebody is a timid guy, he say he doesn't have a backbone here, right? Now, what is this well-established natural law? I am a Homo sapien belonging to phylum Vertebrata. In that, I am in subphylum Mammalia. How does reproduction in mammals take place? There is a male gamete, there is a female gamete, male and female gamete join, there is a fertilization. After fertilization, there is meiosis, and meiosis is followed by mitosis. This is how a biology teacher will explain you reproduction in mammalia. Now today, what do you have? As you are born, you have this amniotic fluid, right? And the amniotic fluid is collected. Now there is a cryogenic therapy also, and that can be stored in cryogenic conditions and kept for about 40, 50, 60 years in a dormant condition. Now when any of your organs fail, your own amniotic fluid can be used for the purpose of harvesting the stem cells. And if you want a kidney, it can be produced. If you want a liver, it can be produced. Your own liver, right? This is the cryogenic technology that offers to you. Now what does it mean? Cloning. My own cell can give me a male gamete. My own cell will give me a female gamete. So I will have 100% replica of mine as my progeny, which is hitherto not possible, right? It's obviously contrary to the well-established natural law. A man can never produce an egg and a woman can never produce a sperm. This is the natural law. But what does the cloning do? Cloning, you go to a stem cell harvesting, use your stem cell to produce an egg, use your own stem cell to produce a sperm, so you have 100% replica of you, right? Now, look at this actually. Look at this and question for yourself whether this is patentable. This is an invention. Actually, I very strongly recommend you a website called Weird Patent. There are a lot of inventions which are weird here. I am sure that world will be better off without such inventions here. Now, please remember, in Goa beach, bear sells. You know why? The Goan beaches are very hot, okay? Around 30 degrees Celsius throughout the year. But you like to drink your beer with a temperature of about 6 to 7 degrees Celsius. So when you get a 7-degree beer to the beach, which is hot, 35 degree, okay, the beer gets very warm. So you want to keep your beer cool for a long time. So what do? You invent a beer umbrella. Okay, a small removable umbrella approximately 5 to 7 inches in diameter attached to a beverage container in order to shade the beverage container from the direct rays of sun. Is it good? Is it useful? Okay. If you are a beer drinker, committed to drink beer at that particular 6 to 7 degrees Celsius, you may think it is a good invention. But in reality, this is not a patentable invention. You know why? That is what we call it as obvious to a person skilled in the art. Human beings have known how to protect themselves against the sun rays when it is hot. They have used an umbrella. So instead of protecting your own self, you are simply protecting your beer can. So it lacks inventive strength. Okay, this is obvious to a person skilled in the art. Now beer umbrella, you see the patent specification. This is patented somewhere else. suitable for advertising. Logos may be applied on the surface for promotional purposes. The umbrella may be attached to a beverage container by clip, strap, cup, foam insulator or the coaster line. There are several combinations possible. The umbrella may also be provided with the pivot to allow. Umbrella may be suitably angled to shield the sun or for aesthetic purposes. Sometimes the sun will come direct, sometimes it will come from a direction. So you can change the alignment of the umbrella part to ensure that you nicely protect your beer to ensure that it doesn't get unreasonably warm. So this is the kind of thing. Now, this is a very interesting invention. This is a patent, mind you. Until I read this specification, I never thought much about the dimples actually. You know that people rightly or wrongly believe that dimple adds beauty to a person. At least there is a perception that people with dimples are lucky people, right? Now, I am not naturally blessed with a dimple here. So what do? This inventor claimed that people are unhappy because they are not born with dimples, right? Okay, when I was a child, I had a curly hair. Somebody had a straight silky hair. I liked the straight silky hair of my friend, and my friend always said that he liked my curly hair. Okay, so we always tend to like things that we don't have actually. Okay, doesn't matter, that is life. We will cut this out. This guy says people are unhappy because they are not born with dimples, right? So what can you do if you are not born with the dimple? You can use this apparatus and get the dimples you want. How do you do it? This is the claim of the dimple making device. Mind you, this was a product in the market. The dimple producing device has a round tip made of either ivory, marble or India rubber. To produce the dimple, simply press the dimple drill tip at the desired dimple lacking area. You keep it like that, okay? And turn on the knob, rotating the dull tip to your face like a drill. The inventor says that this can also be used to nurture and maintain already existing dimple. Now I have a dimple because the first row of my teeth have been removed. You understand what I am saying, So the inventor says it may also be used for the purpose of, that's why I told you, I refer to you, what are known as weird patents, okay? These are weird patents, and it comes with the product liability warning also. If you rotate the knob too hard, you will end up with the hole in your cheek here. Be very careful when you use this product actually. Okay, now that's about 3A. Now read 3B. I always told you, read it. I am going to give you a 30 seconds break. Okay, unless you read it and apply it with reference to the given cases, you may not be able to pick up the skill. The invention, primary or intended use or commercial exploitation of which would be contrary to public order, morality, or which causes serious prejudice to human, animal, plant life, health, or to the environment. Okay, read it again. An invention, the primary or intended use or commercial exploitation of which would be contrary to public order, morality, which causes serious prejudice to human, animal, or plant life, or health, or to the environment. For example, What is the intended use of this pen? This is a pen. The intended use is to write. But I find my ear to be irritating. So I use this pen for the purpose of cleaning my ear. I am sure many people do that. We shouldn't be doing that actually. You understand? That's not the intended use, right? The intended use is to use the pen for the purpose of writing. But nowadays, you have a pen that comes with the clock, right? And you have a pen that comes with multiple applications actually, okay? Now, this is a problem. I'll give you 3 illustrations, okay? Number 1, nowadays, most of the people, most of the patrol vans of the police, we have what are known as the smart patrol vans. If you are in cities like New Delhi, Bombay, Delhi, Hyderabad, Bangalore, the patrol van of the police has got radar guns. Okay? They will know the speed of the coming vehicle. Some roads have a 50 kilometer speed limit. Many people come at 60 kilometers and then argue with the police that their speed is only 50 kilometers and the policeman is abusing the authority. So the policeman will show the computer screen in the van and it will exactly focus your car, your number plate, your image and say exactly the speed at which you are traveling. Now what do I want to do? I don't want to get caught by this policeman. And I know they use a radar for the purpose of calculating the speed of a moving object. So what do? I invent a radar jamming device and I keep the radar jamming device in my car so that if the policeman wants to calculate the speed in which I am traveling, he will not be able to do it because the radar jammer will make sure that the police are unable to take the reading. Whether this invention can be patentable, please remember this would be contrary to public order, commercial exploitation of which is for the purpose of breaking law, right? Now, this is one illustration. 2, you come up with what I call, it's a very provocative illustration. I don't know whether I should say it in an online class. I always say it in a regular class, okay? For example, we belong to phylum, subphylum Mammalia in vertebrata as a thing. Now, normally, human beings achieve sexual fertility when they are about 14 to 16 years of age. That's the ideal thing, okay? Right? But now you have hormones, particularly the hormones which are used for the purpose of fattening the chickens, right? To ensure that a broiler chicken grows within about 45 days. The side effect of it is that sometimes girls who are about 7 or 8 years old achieve puberty because they have been using the chicken which has been fed with the hormone which is used as a growth inducing chemical. Okay. Now here is, if I come up with some substances, can it be patentable? To me, it is a bad invention here. Let me tell you that. But at the same time, there may be a lot of people who may have deficient growth, right? Now, if they are going to find one good use, right, that becomes patentable. For example, the radar jamming device. Now, if I project the invention as an invention that will enable me to escape the radar gun of the patrol van, it is obviously contrary to public order. It will enable people to break the law. So therefore, patent office will say it is not patentable. But the same technology my fighter pilots can use when they fly over the enemy territory. Right? And if I projected primary or intended use, commercial exploitation, this will be, if I'm able to find out one good intended use, notwithstanding the terrible effects that the invention will do, okay, it will become patentable, okay. So, you should know how to overcome section 3B, okay. Then, let us take some bad patent. For example, when this color Xerox came, suddenly the counterfeiting increased in some parts of India because they are not really used to a 500 rupee note or a 2000 rupee note in a rural area. Now currency copier, okay, the color Xerox, right, which can even replicate the line, water line, right? That is something contrary to public order. An invention which enables private assassination, something which poisons people, some invention which may promote debauchery, right? I told you about a date drug, the patentability of a date drug. They are all come under this category, okay? So what is important is that an invention may have a good use and a bad use, right? An invention may have a good use and a bad use. But if you are able to project one good use, notwithstanding the fact that the invention will produce some bad effect, it will still become patentable. That is the moral I want you to learn. Now in this case, look at this. Funk Brothers Seed Company versus Calo Inoculants Limited. See, you know that, the process of nitrogen fixing. And there is a phylum, subphylum in botany, Leguminaceae, legumes. They were dur dal, moong dal, arhar dal, chana dal, kesar dal. There are several dals, right? Now, these dals are leguminous crop. Legumes means they burst open and they facilitate the spreading of the seeds. And all of them, you see the root portion, they have what are known as root nodules. The root nodules have a bacteria that convert the atmospheric nitrogen into a chelatable nitrogen. So that is why farmers will always put a leguminous crop once a year so that it facilitates better nitrogen cycle. Nitrogen, you know that urea is the only chemical fertilizer that supplements nitrogen in the land, and urea is a very poisonous thing. And this method of fixing nitrogen in the soil is far more safe. So the scientists find that 6 strains of bacteria play a very crucial role in the fixation of nitrogen. Now what do? When you inoculate the dal seed, right, with these strains of bacteria, when the dal seed grows, they have copious quantities of these bacteria which will increase the amount of nitrogen which has been fixed in the soil. So this is a very good invention. But the Supreme Court, US Supreme Court held that this is, what I call mere discovery of a scientific principle, formulation of an abstract theory, discovery of a living things, or a non-living substance occurring in nature is not a patentable invention. See, please remember, actually, this subject, section 3, in a normal course, we take about 5 to 6 hours to cover here. because every subclass has to be taught with reference to specific illustrations, and there may have been decided cases on each one of the exemptions actually. Okay, but I'm not going to have time, and therefore I have to necessarily run at a fast pace. For example, formulation of an abstract theory is not patentable. You know the Newton's very famous laws of motion. Most important is, for every action, there will be an equal and opposite reaction. This holds good to sociology also actually, okay? Not only in science, but it almost holds good in different aspects of human relations also. Now, abstract theory, every action, there is equal and opposite reaction. Now you know the internal combustion engine. How does it work? There is a chamber. The chamber has got an inlet means to provide a fuel. And the fuel is evaporated within the chamber. And there is a spark plug. That spark plug provides a ignition, right? There is a small spark, right? And that ignites the engine, vapor, okay, fuel vapor. And the fuel vapor is allowed to escape through an aperture. That is a jet engine. Newton's law of motion, for every action, there will be an equal and opposite reaction, is not patentable. A jet engine which exactly incorporates this principle, okay, is not patentable actually. All right. So I have talked to you about this Funk Brothers case. Now let us look for, see, this section 3D is a very important thing here. And usually Nalsar patent lectures have more people from the pharma industry. Please remember, if you are wanting to be a pharma patent professional, this section is extra crucial for you actually. Okay, there are quite a few. Life science also are important. Now what I am trying to tell you is read it. Mere discovery of a new form of a known substance. We will stop here. Water, ice and steam. Right? It's the same. Different forms of water. If it is above 100 degree, it becomes steam. If it is below 0 degree, it becomes ice. Between 0 to 100 degree, it remains in the liquid form. Okay. So, the first sentence tells you a mere discovery of a new form of a known substance. In other words, if water is known, steam is not patentable. If water is known, ice is not patentable. Okay. Now please remember, which does not result in the enhancement of the known efficacy of that substance, or mere discovery of any new property, or new use of a known substance, or mere use of a known process, machine, apparatus, unless such known process results in a new product or employs at least one new reactant. Okay. This is very important. Mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy. People in the pharma industry, see the word efficacy to me, I am a non-pharma guy here, lawyer, okay, at that. In fact, when I was young, I wanted to be a scientist. But I scored very badly during my graduation days. Couldn't have got a seat for MSc. That was the basic minimum qualification for you to become a scientist those days. So I joined law, right? Now, for me, the word efficacy means more efficient than what it provides. You understand what I'm saying? But in pharma, the word efficacy means the ability of a molecule to cure a disability or disease. That is what a pharma person, that's how the pharma person understands efficacy. And on this meaning of the efficacy, we had this Novartis case. We will probably discuss about this Novartis case. And I think we are getting close to the end of our allotted time. Known efficacy of that substance. Novartis case, imatinib mesylate, crystalline form of imatinib mesylate, beta crystalline form of imatinib, you know the Gleevec, we are going to discover a mere discovery of a new property, new use of a known substance. For example, aspirin being a blood thinner, okay. Aspirin was a wonder drug invented in 1940 for the purpose of acetyl salicylic acid, painkiller. Now it is used as a blood thinner. That's a new use of a known substance. And this can have application in treating people having blocks in the coronary artery. What do you call? Aspirin combination drug. You know, if you are going to give it to a person having blocks in the coronary artery, that will substantially reduce the risk of heart attack. Okay, this is a new use of a known substance actually. Can you share slide? And I am sharing you all the slides, ladies and gentlemen, don't worry. But I am just putting up the slides for you to apply with reference to a case that I am talking. Follow the case, please. New use of a known substance. Mere. See, one more thing I want you to focus here. Please read this. Okay, it's a very important thing. If you have read it, reread it. Okay. Nobody understands everything on the first reading. Okay. And believe me, I have read it hundreds of times. And each time I read, something I manage to learn in this. You see the word mere discovery. New form of a known substance. That does not result in the enhancement of the known efficacy of that substance. You know, the word efficacy means something to a lawyer, something to a pharmacologist, something to a chemist, something to a physicist, something to an engineer, something to an economist. Okay, the meaning of the word efficacy is very important. It became a subject matter of litigation in the Novartis case. Imatinib mesylate, beta crystalline form of imatinib mesylate. I'll talk about it in our next class. Okay, then again you find the word mere use of a known process, mere discovery of a new property. And mind you, the word mere is used in section 3E, a substance obtained by mere admixture resulting only in the aggregation of the property, mere arrangement or rearrangement or duplication. So you find the word mere is presented in several sections. And what do you understand by the word mere? Okay, now let me give you my explanation. Patent law is all about specification. When you can say something in 2 words, when you use 3 or 4 or 5 words to explain the same thing, it becomes unclear or indefinite. You know, a patent specification's biggest vice is lack of clarity. Okay, and that we should avoid. A mere, to me, in English language, means just that. Okay, am I right? You can give your comments on my understanding of the word mere. Mere simply means just that. Okay. What is just that? If you are a very rich person, can say $1 million here. Hey, just that. Narayan Murthy's daughter Rakshada Murthy gets about 10 million pounds every year as a dividend, and she has got something like $80 billion, right? Now we are going to understand the meaning of the word mere. This is very important and it's a context which determines the meaning of the word. Now I'll end this clause with a joke. Patent office. You can't get a patent extension for changing the color of the pill. Can you? Viagra came up as a blue diamond. Now India, when it came, Viagra became a pink cylinder, right? But whether it is a blue diamond or a pink cylinder or a pink square or it's going to act the same, right? It's not going to make any significant improvement to the way the sildenafil citrate functions as a molecule in your body actually. Now you can't have a patent extension for changing the color of the pill. But changing the color could increase public acceptability. You understand what I am saying? For example, there was a very important product, calcium Sandoz. Sandoz came up with the calcium pill, especially targeted for children and pregnant women. They were selling it in a cylindrical container. The sales weren't good. But they made the container into a teddy bear which the children can use it for the purpose of keeping their pens and pencils. After introducing that container, the sales of calcium Sandoz pill, shot up. Okay, now ladies and gentlemen, this is important and I am done with this really. Explanation to section 3 clause D. 100% formal specific this is. For the purposes of this clause, salt, esters, ethers, polymers, metabolites, pure form, particle size, isomer, mixtures of isomer, complexes, combination and other derivatives of the known substance shall be considered as the same substance unless they differ significantly in properties with regard to efficacy. Now, earlier I asked you the meaning of the word mere. Now I am stopping with the question, what is the meaning of the word efficacy?